the Honorable Yonette Cummings Edwards, our distinguished Chancellor of the Judiciary, the Honorable Roxanne George Wilshire, our Chief Justice, our visiting dignitary from UNICEF, Mr. Nicholas Prone, and I ask your kind permission to adopt the protocols and salutations so elegantly articulated by our chairperson. It is indeed an honor for me to be afforded an opportunity to share this podium this afternoon as we celebrate another simple but historical and significant milestone in the administration of justice in our country. Yesterday, I accompanied our distinguished Director of Public Prosecutions, and we declared open a brand new edifice at Onderneming on the Essequibo Coast that will house residential accommodations as well as office accommodations for that important office of the Director of Public Prosecutions. Today, I am here and privileged to associate myself with this, another historic event, that is the establishment of Guyana's only second children's court and the first outside of the city of Georgetown. We speak many times in our government about transforming Guyana, and that transformation is permeating all sectors of our country. The legal sector, obviously, very much in the forefront of benefiting from that transformation. As our government sees the judicial system, the legal system, the rule of law, and its enforcement and applicability as central to the development of our country and the advancement of our society. I said yesterday in Essequibo that the history of man is the history of a struggle for freedom and justice. And empirical data will establish beyond doubt that no society has ever advanced, no country has ever developed without a functioning, efficient, and efficacious judicial and legal system. Because no matter how much we try as human beings, we find ourselves in conflict with the law. I wish to adopt the admonition of the learned Chief Justice when she said to our students that it is our collective and sincere hope that you will never have to use these facilities. But that is only our hope. The reality is, and I'm not calling this upon you, that you will inevitably, whether innocently or by design, will have an engagement with this facility, the children of these community, or else we would not have seen the need to build such a facility here. And over the years, over the centuries for that matter, the inconvenient truth is that more and more of our citizens and citizens across the world engage with the legal system in progressively increasing numbers. Our government recognizes that. And that is why the transformation that I speak about is not manifesting itself only in the construction of physical structures and in capital type projects, but also at the level of policy and at the level of legislation. So in 2018, we promulgated our first juvenile justice legislation. And I want to recognize the important role that UNICEF played in crafting and eventually finalizing the product which we now have, and their continued assistance to us, because we only last year reviewed that legislation. And there is some view among our police officers, and I am happy that the commander is here, that the Act does not permit juveniles to be charged. Let me reject that notion absolutely. The DPP has given clear advice on the matter, but still at the level of central government, we get reports that police are saying to persons in the communities when they make report that the police are prohibited by law from investigating and charging juveniles. That is not so. You obviously are empowered to charge and treat with juveniles, but in accordance with the provisions of the Act. And the Act also provides for how they are to be treated when brought before a court. So it's an entire statutory code that governs the treatment of juveniles and their incarceration, pre-charge, post-charge, and post-conviction as well. So it's a complete statutory code. Importantly, we are currently engaging in reviewing our Sexual Offences Act, which we enacted in the year 2010. Again, UNICEF played a significant role in helping us conceive and design that important piece of legislation. And after 14 years, we are conducting a desk review, a comparative analysis with similar legislation across the Commonwealth, and of course, reviewing a decade of its operation, or 14 years of its operation, with a view to identify the deficiency that we would have unearthed during that period of time and to address them. The bill is currently out for consultation. I am told by the consultant that in formulating the bill, she held consultations with judges, the Director of Public Prosecutions, prosecutors, the police, and magistrates, as well as victims and persons charged under the Act. But that consultative exercise is ongoing. It is not concluded. So please, if you have any additions to make to what you may have already contributed, please feel free to access the bill. It is online from the Ministry of Legal Affairs website, and the consultant, if you wish, can meet with you as an institution. For example, meet with all the magistrates, meet with the judges again, meet with the Director of Public Prosecutions and our team, meet with the police and their team, and go through another installment of consultation. In the Parliament, we have the Abolition of Preliminary Inquiries Bill, which we will be debated just after the first week of June. That's another critical piece of legislation that will impact the criminal justice system in a fundamental way. In that legislation, we will completely move away from oral preliminary inquiries, and we will treat exclusively with paper committals. That should bring tremendous relief to the workload in the administration of criminal justice, bring speed to the disposal of cases, and have a positive impact on our growing prison population. And there are many other very crucial pieces of legislation that exclusively touch and concern the administration of justice generally, but more particularly the administration of criminal justice, that we have just passed or are in the pipeline. We just concluded, for example, the plea bargaining and plea agreement bill, and we now have that modern system whereby the DPP and accused persons can enter into plea bargain and plea deals even before the charges are filed or even during the cases. And that again is another fundamental piece of legislation that will impact the workload, impact speed, and impact efficiency in the administration of criminal justice. The government is partnering with the judiciary in every way possible to ensure that the judiciary is adequately resourced, because, as I said, we recognize the importance of access to justice across the length and breadth of our country. I think I have received an indication already from the Chancellor that I'll be accommodated to a long sojourn with our new boat to Region 1, where we will declare open either both or one magistrates court, one at Port Kaituma and one at Mabaruma. And you will note that all these courts are built in a particular style and built with a particular reservoir of amenities. They have living accommodations, some of them have elevators, they provide for the less abled, and they are very modern as you can get in a magistrate's court. Chief Justice George referred to the first time she came to this court. I remember doing my in-service with Mr. Ludnath Singh, and we came to this court, Wales Magistrate Court. It's a completely wooden building, and the well of the court, that is between where the magistrate sat and where the bar table was for the lawyers and the prosecutors. There was a gaping hole, a huge hole in the middle of the court you could fall through. When rain fell, the magistrate was forced to adjourn court. That is what we came from just a few years ago. Today, when I entered this compound after some time, I couldn't believe the resplendent facilities. So the transformation about which we are speaking is actually taking place before our eyes, and we must reflect upon the fact that we mustn't take these things for granted. They come at great sacrifices. Millions and millions of taxpayers' monies are used to construct these edifices, and therefore we have to ensure that we use them fully and we take care of them. And I speak now, I see the regional chairman here and other regional officials, but most importantly you, the people of the community. You are fortunate. Region 3 is quite large. Starts from the Essequibo Islands and it gone way down this road. And your community was chosen. We could have chosen Reed and Hoop, that may be considered more central. Could have chosen Lenora. After all, the president is from there. I'm not saying that that should have been the reason, but it's again very central. But you are fortunate that this place is chosen. So you are very lucky. And as I'm on the courts, we, the Chancellor, the Chief Justice, and I guess the great team supreme, will be visiting a site at Tushan where we will, I don't know, turn the sod or at least agree that another magistrates court will be built there. One is being constructed at Perfect Harmony as we speak. So this is the transformation that I am speaking about. And it's not happening only. People might be asking, but why are we building so many courts? Why not build more schools for children rather than courts for children? Or pediatric centers for children rather than courts? We are building that too. We are building that too, but we can't turn a blind eye to the realities of the society in which we live. So we have to cater for all eventualities. As I said, it's not the policy intention or the policy directive or any imperative at all that you should engage the court process. But the truth of the matter is, when you travel from Barima, Waini, all the way to Crabwood Creek, then all the way to Oriala, then come all the way to Aishalton, and up back to Barima, Waini, and you look at the courts in that route, you will see hundreds, if not thousands, of our citizens engage the court system on a daily basis. On a daily basis. The courts are as crowded as the mosques, the mandirs, and the churches. It's not what we like, but that is the reality of the society in which we live. And therefore we have to prepare. And I want to assure you that the government of Guyana will stand always with the judiciary in ensuring that we create and maintain public trust, and I'm reading from the mission statement. maintain public trust and confidence through an independent, effective, and accountable judicial system. Because we believe that it is fundamental to our development and advancement that we uphold the rule of law and provide access to timely delivery of justice in a fair, transparent, and efficient manner. I thank you very much for your attention.